This year, we'll be watching 3 interesting trademark and copyright cases on the Supreme Court's docket. The first is VIP Products versus Jack Daniels, involving parody dog toys. If that sounds familiar, it could be because one of the better-known and oft-cited trademark parody cases also involved dog toys, Louis Vuitton versus Hot Diggity Dog and the Chewy Vuitton toys. In this year's VIP Products case, the Supreme Court has agreed to review 2 questions. 1, how far does First Amendment protection extend with regard to humorous commercial use of a third-party trademark? And 2, can the humorous use of a third-party trademark on a product that is offered for sale ever be considered non-commercial use, which would allow it to evade a dilution claim? There's a tension between the protection of trademarks and First Amendment free speech rights, and parody falls at the intersection of that tension. The circuit courts have not treated the matter consistently. In particular, the Ninth Circuit, the circuit from which this case was appealed, has interpreted the scope of First Amendment protection quite broadly. This Supreme Court ruling should help clarify the strength or limitations of a parody defense and should provide helpful guidance both for parties creating products that parody third-party trademarks as well as the trademark owners. We look forward to this clarity. Another important case is Abatron Austria versus Hetronic International, which will address the scope of the Lanham Act's extraterritorial reach. The Supreme Court's opinion here will likely resolve a circuit court split over the correct test to determine whether the Lanham Act should be applied to acts outside of the U.S., including foreign sales that do not necessarily touch the U.S. Counterfeit goods continue to be a significant issue for brand owners and the public generally. So this case is very timely and may affect a broad scope of industries. The court's decision may provide trademark owners with another tool for tackling the increase of foreign counterfeit goods and affect a company's ability to obtain damages for trademark infringement that, at least partially, takes place outside of the U.S. Finally, we are also watching to see how the court will treat artistic works in its decision in Andy Warhol Foundation for the Visual Arts versus Goldsmith. This copyright case focuses on the distinction between derivative works and transformative works and the scope of the fair use doctrine. If Andy Warhol's famous Prince series is a transformative work, then it may be protected under the doctrine of fair use. If it is a derivative work, then it may constitute copyright infringement, since the right to make a derivative work is one of the exclusive rights granted to a copyright owner. The implications of this decision could be far-reaching, as any further guidance about where a derivative work ends and a transformative work begins arguably impacts the scope of protection offered under the copyright law. For example, this case may help clarify whether NFTs and other types of digital art are independent works protected via the fair use doctrine, or if they require a license from the original copyright owner. We'll be following these cases closely and updating our clients on their implications as the year unfolds. In the meantime, please review additional videos in McDermott's 2023 IP Outlook series on our website. We're examining top trends and decisions in IP law from the past year and sharing what you and your business should look out for in 2023. Thank you.